Welcome back to the Legal Paige podcast. I'm your host, Paige Griffith, and today we're diving into a topic that sometimes is a bit uncomfortable, but it's truly essential for your business's financial, legal, and customer health. You know all those taboo topics you're not supposed to bring up at the dinner table? Well, I'm going to break the mold and tackle one of them, which is your business finances and slower than normal sales. Specifically, how slow sales or taking sales back might be affecting your bottom line and what you can do about it legally. As business owners, we do often put our clients' needs before our own, sometimes to the detriment of our own financial well-being. But here is the hard truth. Your money is just as important as your client's money, and it is not greedy to prioritize your own bottom line, especially in challenging economic times like we have right now. So in today's episode, I am getting into 3 big legal topics that have popped up recently in the TLP community on Facebook. It's a free private group that you can totally join if you're an entrepreneur. And I really wanted to share my deeper insights with you on these 3 things. The cooling off rule when clients cancel contracts soon after they sign and how that rule applies to you. No downgrade language in your fee clause if a client asks to reduce the fees and services agreed to in the contract that you all signed. And fraudulent chargebacks, or what's called friendly fraud, quote unquote, when clients file illegitimate chargebacks just to get a refund, even though you've already performed services and fulfilled your end of the contract. Sound juicy? Let's do this.
You're listening to the Legal Paige podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. As a reminder, before we get into this episode, I am legally obligated to give my disclaimer. I am an attorney, but I am not your attorney. All legal information I talk about in this episode is intended for the masses and a large variety of different businesses. Please seek out another attorney in your city and home state if you need specific legal advice related to your unique business. Okay, let's get back to it.
It's 2024. We are coming off of 4 years of really financial oh-crapness. And I bet that many of you listening are feeling the pinch of slower than normal customer or client sales. And guess what? You're not alone. We're all in this boat together. It's not a fun boat to be in, but here we are. And in today's market, the main thing that I have been seeing pop up time and time again is that customers are more cautious with their spending. They are very aware of how to get out of things and utilize kind of consumer protection on their side, which ultimately means that you as a service provider could be facing more cancellations or people asking to change things with the services that you agreed upon, rescheduled appointments, refunds, etc. I just don't want you to panic because there are steps that you can take to protect yourself and your business. Speaking about business though, can we talk about customer service for a moment? It's not just about being nice, right? Of course, customer service is incredibly important, but customer service is also about setting boundaries and standing firm on your policies. That shows that you are a good business owner and a professional one at that. Yes, of course, you want to provide excellent customer service to your clients, but it doesn't mean that you have to bend over backwards every time they ask for a refund or a discount or a change to your contract. And here's the thing, remember, don't fall prey to people pleasing in this respect because it essentially nullifies your contract, or at least portions of your contract that your client is asking you to change, or basically kind of strong-arming you emotionally into people pleasing. Clients sometimes just feel like they have the upper hand and can ask for changes or not uphold a clause as you have already written it out for your business protection and the business policies that you wanted to implement in the first place, and that they agreed to when they signed the contract. They had every right at the beginning to try to change things or have negotiations with you on your business policies that are outlined in your service contract. It's your contract. You're the business owner. All right. So, what does all this mean? Like, what am I trying to get at here? There is some nitty gritty legal stuff that I want to go over in this episode related to this. And it's three big things that continually happen with clients trying to backpedal or change things to benefit themselves financially that ultimately cause extreme harm to your business. Here are the three big things. One, the cooling off rule, and what this means when clients kind of have buyer's remorse. Two, no downgrade language in your fee clause and how it can save you if clients are wanting to backpedal and get a smaller package or not pay as much to you. And three, fraudulent chargebacks, what's also known as friendly fraud, that is on the rise, especially in the newer generations. And we're going to talk about this because it's an issue. Service providers don't like it. Paying online with credit cards is just becoming more and more of an issue. And bank fraud, illegitimate bank fraud, under this number three. All right. Let's start with the first, the cooling off rule. Did you know that clients can legally cancel their contracts and demand a full refund within a certain period of time after signing? So it's called the quote unquote cooling off rule. And it's something really every entrepreneur should be made aware of. But what exactly is it? So this is a way for your clients or your customers to get out of a contract really just due to buyer's remorse. They're like, I don't want to do this anymore. I feel really weird about signing off on, $2,000, $5,000, $10,000 plus under this service agreement. So the cooling off period, though, varies by state. It is generally around 24 hours to 3 days, right? So it allows you some time to really reminisce on what you just signed, what you just agreed to. A lot of times this has to do with like real estate contracts at a convention, or say when a salesperson like knocks on your door and comes to your house and they use all of these like crazy sales and marketing tactics to like get you to buy something. There's a lot of different qualifiers per your state law to the contract that could have been signed, right? So just remember that this may not apply to your service contract that someone would be signing online. However, I think that legally speaking, it could apply to many, many, many service providers online. So it's really just good to know, what is my cooling off period in my state? And can I just wait until after that cooling off period to be like, yes, I finally secured and validated that contract with my client? We are actually seeing in the service provider kind of online industry world, or, in-person services, but a lot of them are also done online. We're seeing more and more clients take advantage of the cooling off rule. So here is my legal suggestion from your friendly attorney. As a savvy entrepreneur that you are, just never, ever use funds from a signed contract before the cooling off period has passed. Otherwise, you could be required to return the money that you spent. And oftentimes it's just not worth it for you to try to fight the cooling off period, unless, there are facts and circumstances in any situation that could arise where I'm like, yeah, fight it. Like, I don't think the cooling off period applies to you in this contract that you signed. But in the majority, I would say like 95, 99% of situations, for all of you that are probably listening here as service providers and entrepreneurs, it's just not worth it to fight whether or not the cooling off period and rule in your state applies to you. It's better to just know what it is. Is it 24 hours? Is it 72 hours? Is it 7 days? And then just always, always, always abide by that. The contract is signed. Awesome. Now I'm just going to start the clock. 3 days later, boom. This contract is 100% valid. I don't even have to worry about a cooling off period. So I want you to understand the specifics of this cooling off rule that I am talking about in your state because it's crucial for you. As a service provider, it helps you protect your business and ensures that you're not spending that retainer payment on anything in your business before the money is actually yours, AKA after the allotted cooling off period of time is over. So, what do you need to do? I can't tell you exactly what your cooling off rule is. There are 50 plus of them. So go research your specific state law on this and stay informed. I suggest that you simply Google, quote, cooling off rule in, quote, X state. And then just be sure that you're on a government website, right? .gov websites. I always suggest that you're landing on those and not some random blog. And make sure that the Gov website is pulling up an actual law or regulation in your state and they're interpreting it, or you're reading the actual law as that law is written. Okay, so number one, cooling off rule. It's a way for clients to financially back out of something, and maybe a really large service contract that you were super excited to get and book with them, but they have some buyer's remorse and they don't want to do it anymore. I just want you to be aware of this, and clients are becoming smarter and they are invoking this cooling off rule. No downgrade contract language is the next thing I want to talk about. Clients do want to downgrade more often than not now in today's financial climate. And that is simply due to the fact that maybe they had a budget for, say, X event, and you are one of the most expensive vendors at X event. And now X event has gotten way too expensive. They've gone way over budget and they need to dial it back and cut back. So they're probably going to go to the most expensive vendors and figure out how they can work with them and not just cancel on them, but maybe how they can downgrade their package. I'm going to stop here before I even get into the no downgrade contract legal language thing and say, you run your business the way you want to, all right? If you are cool with dealing with these types of one-off situations, or they're becoming, more and more prevalent, and as a professional, service provider, you are willing to deal with downgrades, essentially still keeping these clients, but are willing to work with them on their budget. Maybe you just, this is a possibility of happening 10% of the time. So you budget accordingly and maybe price your packages accordingly, then you do you, my friend, okay? That's fine. I'm not saying that this is the one way, be all end way of doing things. This is just a contractual legal suggestion for you on really how to protect yourself from clients not even getting to the downgrade situation. So it's a clause in your contract within usually your larger fee and retainer clause. And it's just legal language related to no downgrades that your clients agree to. It's really just a little paragraph in your fee and retainer clause that explains your business policies surrounding the package that was agreed to is what is going to happen at the end of all of you completing payments and completing services and performance under the contract. And that no downgrades will be allowed, but your clients could say upgrade at any time with a mutual agreement of both parties. Just having that little sentence is an easy way to point your clients to when that situation were to pop up, if they wanted to downgrade. You don't have to come up with all of these reasons why you don't want to offer this type of customer service, or, your clients are going to think badly of you, or what. Like, one, your clients could just look at your contract before even sending the email to you asking to downgrade. They see that there's no downgrade language in the very beginning of your contract under clause 1, which is your fee and retainer clause. And they're like, cool, not even going to send that email because I've agreed to what I've agreed to, and that would be breaching the contract on my part, so I can't even ask them, But maybe they don't, A, look at your contract, or 2, they look at your contract and they're like, I'm still going to try. And then you can point to that clause easily. It shows that you are going to enforce your contract as written. And it's just an easier way to get out of that situation. Again, you can do what you want as a service provider. And if you feel the need with the facts and circumstances of XYZ case to change it up and maybe like willingness to work with clients, that's fine. But in most cases, clients are just wanting to pay less. And they're going to see if you're willing to work with them. And if not, then they could get dicey and yeah, it's just a whole situation. And just remember, again, your money is just as important as your client's money. So there's an opportunity cost here. You lost out on the potential to say yes to another client that may have booked that package that you already agreed to with this client, or a higher package that your client, solidified that date on the booking calendar with you, and you couldn't say yes to anyone else. And now you were like, okay, I'm fine with this middle package. I could have booked a higher package, but this one is my average and I feel good about it. And maybe if this client would have inquired about a lower package to begin with, you would have maybe not thought that they were your ideal client and you would have waited. Say this was like 18 months out too. Okay, I'm getting way deep into facts and circumstances here. Again, there's so many things that could happen in these scenarios. So I just suggest you put no downgrade language in your contract. There is no harm, no foul in doing this. And in most cases, it's going to actually save you and protect you and allow you to just point to the clause and not have to deal with this like customer service wise. But here's another scenario. When I talked about this no downgrades language, I believe it was on Instagram, someone asked me when I originally posted about it, can't the contract just stand without having to spell this out in a clause? Like, do I actually need no downgrade language in the clause? They are correct. You don't literally need it. Like, it doesn't make your contract more valid, right? But, and they're saying like, wouldn't this situation be just canceling that contract and booking a new contract with the new services that you all agree on? I mean, kind of, right? Like you could do it that way, but that's cumbersome and it doesn't really make sense. What your clients are actually just asking is amending the contract as is. It could easily just be a people pleasing moment. And your clients are saying, hey, can we alter this portion? And maybe you're just offering this service. Maybe I don't need, your assistant there day of, or maybe I need less services from you or less deliverables from you. That's what they're trying to avoid, which is paying for these extra things in your contract and kind of in your scope of services. So in most scenarios, it's not going to be a full-blown cancellation in a new contract. It's just going to be amending the contract. And also intuitively, clients understand that more. They're like, wait, no. I was just asking to change up this little portion of the contract. I don't want to cancel and sign an entirely new contract and deal with all of these new policies from you. Okay. So that was a situation that I just wanted to go over here. And then another good option is that you could have clients initial your fee and retainer clause if you've been experiencing more and more clients asking to downgrade. And it's just one of those things where I tell people business is a journey. It's not a destination. And especially in the service provider world where we're like quasi in person and quasi online, or maybe you're providing all your services online behind your computer, there are things that are going to change and happen throughout the course of you doing business where you are finding your ideal clients are in, a certain economic bracket, or there's things that are occurring just in the world with inflation where everyone is having to kind of relook at things. But your costs are also increasing as a service provider. And again, I'm going to go back to here. The main thing I want you to remember is the money that you agreed to in that contract coming into your business is extremely important and for you to hold on to, because there is likely a cost of you downgrading and not being able to book other people for those services because there's just no way. All right. So that is number two. It's a financial thing that's happening, a way for you to avoid it and really just combat this with simple contractual language. And if you're looking for, okay, Paige, how do I actually write this language in my fee and retainer clause? We have a la carte clauses at thelegalpage.com, and no downgrade language is in our longer fee and retainer clause that you can purchase separately and put in your contract. If you already have a full length TLP contract, you don't need to buy this a la carte clause. Our fee and retainer clause in every service contract is really comprehensive and it includes no downgrade language. But if you have maybe some other contract and you have an existing one that you're comfortable with and you just want to bulk it up and protect yourself more and add in this a la carte clause, it's great. The fee and retainer clause also includes so much more than just no downgrade language. So you're really like killing a lot of birds with one stone, or however that metaphor goes. Okay, so we talked about cooling off rules, cooling off periods. We talked about no downgrade language, adding that into your fee and retainer clause. And now I want to talk about the juiciest one, which is fraudulent chargebacks. Who here listening is a victim of chargebacks? Ugh. I'm raising my hand because we deal with it. Like every business deals with chargebacks. It is not fun. But here's the thing. I have won chargebacks. And I want to basically tell you how to win chargebacks, especially when they're fraudulent. And what do I mean by fraudulent? So when clients wrongfully dispute transactions to secure a refund, despite the completion of services or delivery of products clearly stated in, say, non-refundable terms to your service agreement or to your online click wrap agreement or your digital purchase agreement, if they're asking for a refund just because they want their money back, you're dealing with a fraudulent chargeback. This is also called quote unquote friendly fraud in the online business and chargeback world. It sucks. Point blank. It is not fun to deal with, especially when you have invested time, effort, and resources into delivering your expertise only to face an unwarranted credit card dispute. It's just terrible. And then when I was talking about chargebacks with, I believe it was our Facebook group, someone even in the comment section was linking to articles that Gen Z and all these new generations they know that they are doing friendly fraud. Like they know that this is not a valid chargeback. Like that transaction that they made was a legitimate transaction, but for whatever reason, they just don't want to deal with you and ask for a refund or a partial refund, or they literally just want to be mean. And they think the easiest way out here is to just file a chargeback with their credit card company or the bank. And due to the alarming increase in numbers of chargebacks, banks and credit cards are now most likely going to just side with the customer that they have because that's their banking customer and their credit card customer. So they're hoping that they stay, right? And the likelihood of the chargeback being argued from the service provider or, company that initiated that transaction's perspective is actually really low. So Gen Z is just like, we have a really good opportunity here to get our money back, even though we got services or this product already mailed to us. All right. So with that being said, there are steps that you can take as a service provider to prevent these fraudulent chargebacks. And I just want to walk you through this process that you can take if it happens to you. Number one, clear and comprehensive contracts. I really, really want you to outline the non-refundable nature of your fees, emphasizing that, this terms and condition is what this client has agreed to when engaging your services. And, you have artistic discretion and that is not a valid reason for a refund. And once all of your deliverables have been sent to your clients, then they cannot, file a chargeback or it's not a valid reason for a refund. Number two is just thorough documentation. Okay. On top of your contracts, I want you to just maintain a meticulous record of all of your client communications, the deliverables that you've sent, any emails that you have back and forth. This is really like why a CRM system like client management software is so important, is because they can timestamp and document everything for this comprehensive record. It serves as evidence to dispute chargebacks. And you are probably going to have to send additional evidence to the credit card company or bank when they're like, do you want to respond to this chargeback that was sent in by X client or X customer? And you say, yes, I do. And not only here is my contract and here are all the things they agreed to, here are all of the services I have performed, or maybe I have completed 100% my portion of the contract. And now they're breaching because they didn't want to pay for that. In most cases, that is going to bode very, very well for you in a chargeback dispute. So number 3 is to look for payment processors with seller protections. This is hard. It's hard to do. I want you to choose a payment processor that will allow you to really actively contest a chargeback on behalf of yourself as the service provider. I'm just going to point out here, like PayPal's not a great one. PayPal, like 100, not 100%. I would say like 99.9% of the time usually sides with clients or customers. Although I know people that have won chargeback disputes through PayPal, but it's one of the most difficult platforms to do so. So it's more on the consumer side than the seller side. But there are lots of other ones that I know people have won chargeback disputes through, these fraudulent chargebacks transactions that have been filed. Stripe is another one, and there's a couple others. I know Shopify is a really good one as well. I'm not going to point all of them out because I personally, like, I don't want to give you a suggestion that I can't stand firm on, and I'm just not 100% aware of all of the pros and cons of every single payment processor. So just do your research is what I'm trying to tell you here. Number 4, I would say number 4 under this, step-by-step that I want you to take to hopefully avoid fraudulent chargebacks or at least be prepared for them is a change to how you take payment. And some service providers have been limiting their payment methods to less susceptible areas of chargeback disputes. So you could only take cash or check, or you could just take ACH transfer where you're basically just only dealing with banks. Banks are a little bit easier to deal with than credit card companies. And when you take cash or check, like they're going to have to file in small claims court to get that back. Like there's no intermediary for them to file a chargeback through, right? Because there wasn't a charge. It was just cash or check. Well, check would go through the bank. But again, it's a lot more difficult than an ACH transfer, which is like a money wire transfer through a bank. And check is just really hard because it shows you are writing out the check, and maybe you also disclaim that they put things in the memo portion of the check. Like their actions actually constitute a legitimate way of them agreeing to X contract. Like it's actually evidence against them. So check is a good way to go about it. And I know that some service providers have also just done this for financial reasons where like why pay for these credit card fees that are quote unquote supposed to protect me as a seller when I am going to be charged 3% of the total package price from this payment processor. And I'm going to like probably lose chargeback disputes anyway. And so some service providers have just said, screw it, I'm not going to use, an online payment processor. I'm only going to take cash, check, or ACH. And potentially you offer a discount to clients doing that, or people are charging that 3% fee if your state laws allow you to upcharge the credit card fee. Some states do. I don't like it for like customer service reasons and I don't love it. But if you choose to do that, it is a way for you to incentivize clients to pay via cash, check, or ACH. And it bodes well for future potential chargeback issues that could arise. All right, number 5. Just regular client communication. If you are just a good service provider and you're maintaining open and transparent communication with your clients, you're probably going to address any concerns way more promptly and be able to document all of these communications via email or a follow-up email after you discuss something over the phone. And just good client dialogue is really just invaluable when maybe dealing with a chargeback down the road, which you're probably not going to deal with if you have really good client communication. But it's really also great for evidence and proof when defending against chargebacks. So just remember, good client communication across the board saves you in many different facets. Okay, the very last step that I wanted to go over with fraudulent chargebacks is secure contract signing. This is a legal step I want you to take. So utilize a secure contract signing method to ensure that the client has legitimately acknowledged and agreed to the terms before you commence any services. What do I mean by this? Use an online contract signing platform or a CRM platform that timestamps and only sends the contract signature part to the email with the IP address that it would timestamp as well on file, because all of that is really important for you to be able to show to, have any recourse to a fraudulent chargeback when you're submitting the contract as evidence to the bank or credit card company. If you are sending just like a PDF that people signed online or a Google form that people signed online, you're just giving so many arguments to clients that they didn't actually agree to that contract, or it wasn't a legitimate contract because I actually didn't legitimately sign it. Just don't give them that argument. So implement secure contract signing, use a legitimate contract signing platform or a CRM system, client management system or operating system that you have at your business that is sending secure contracts to clients, and it's timestamping the time, the IP address, and the email address that the signature was acquired from. Okay. All in all, what am I trying to say here? For fraudulent chargebacks, okay, and friendly fraud that is occurring more and more and more, it's not something you can completely avoid. And when this question has been posed in my Facebook group, myself and my legal team are always like, okay, it's just like a necessary evil of doing business and taking payments online. There is obviously a benefit to taking payments online because it's fast and it's easy and it's the way that the majority of people pay nowadays. Also, clients like to get points from their credit card companies for paying for, larger services, thousands of dollars in services. So there are reasons why you would keep online credit card, debit card payment processors for your business for financial and, ease of use reasons. But just remember that you are probably at some point in your career, hopefully you haven't dealt with it yet, okay? But it's not really a if it's going to happen. I really think it's a when it's going to happen now because it's so commonplace, which sucks. But a solid contract is always your primary defense, okay? Like making sure that everybody has agreed to these terms. You can point to these clauses if you're dealing with disputing a fraudulent chargeback. But another good way to deal with this is to add an extra layer of protection because it doesn't hurt, especially if you've been dealing with frequent chargeback issues. So what have I done? I've created an a la carte chargeback protection clause. I don't put these in all of our template contracts because I don't think they are not absolutely necessary. I'm only putting the clauses in our template contracts that are necessary to create a valid contract. Like I said, a solid full-length contract is your primary defense. But if you want to level up a little bit, you can add in this a la carte clause, because it's designed to provide you with additional proof that your clients authorized transactions and agreed not to file fraudulent chargeback requests. Now, this type of clause, it's like a credit card authorization clause and chargeback clause. It is really important for you if you check a box or your CRM system or invoice, contract signing platform has the ability to do recurring automatic payments for, the future payments that are due under your contract. If that is a possibility under your CRM system, then you really need to add this clause in your contract. And of course, you're allowing your clients to do automatic payments because it's showcasing that your clients have agreed to those additional charges. And a lot of times the argument on a client or customer side is, this was a recurring charge. I didn't know it was a recurring charge, and I didn't know they were going to automatically charge my credit card on file. So now this is fraudulent. Like, you just take that argument away from them by adding this chargeback protection clause. So it's an a la carte clause. You can get it at thelegalpage.com. Just type into the search bar credit card authorization and chargeback clause. And yeah, it's a great one to add in. A la carte clause, not strictly necessary with a robust contract, but of course it can serve as an added safeguard. All right, we went over a lot of not so fun financial things to talk about, but really necessary things to talk about due to today's economic climate and really just situations that have been occurring in the online business world, and with clients getting smarter and savvier with how to go about retracting what they agreed to with service providers. What are the takeaways from today's episode? I want you to protect yourself and your business through your contracts as much as possible. This is paramount. 3 things. Remember, retainer fees and their non-refundability occur only after the contractual cooling off period is over in your state. I would say 3 to 7 days is a really good period of time for you to be like, whew, this contract 100% valid. The cooling off period is over. We can move forward with services. Don't move any retainer fees. Don't move anything out of your business, account. Don't even qualify it as your money until that cooling off period is over. Just in case your clients have a little bit of buyer's remorse and they want to back out, you can easily just issue that refund to them. It will help you financially as a business owner. Number 2, please have no downgrade language in your service contract. You agreed to this just like your clients agreed to it. Your money is just as important as their money. And this type of language is really simple, and it's just added to that first clause in your contract, which is your fee and retainer clause. And then the third one is to be aware that fraudulent chargebacks are on the rise, and I want you to be legally prepared. I gave you lots of steps and tactics to be aware of what you need to do if you are fighting a chargeback dispute, or hopefully how to avoid them in the first place. So here's to a more financially sound business. In 2024, remember, your money matters, so don't be afraid to stand up for it. And my friends, that is all for today's episode of the Legal Paige podcast. Thanks again so much for tuning in. And until next time, stay legally savvy, my friends.
Thanks so much for listening to this episode of the Legal Paige podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpage.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.